Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration Law, and today we're discussing the L-1A visa classification. Remember that for all L-1 visa classifications, there must be a qualifying corporate relationship between the overseas entity and the U.S. entity. In addition, the foreign national entering the United States must have worked for that overseas entity for at least one of the past 3 years prior to entering the United States. The L-1A classification is for executives and managers. An executive for L-1A purposes is generally considered to be someone who's working in the C-suite, somebody who directs and manages an organization, who provides very high-level management to an organization, helps establish goals and policies. They have wide latitude in discretionary decision-making, and they receive generally only high-level supervision from an entity like perhaps a board of directors. The question of whether an organization actually needs an executive level worker is one that USCIS will look at, and they will consider things like how many people work in the company overall, what the executive's actual role will be, the needs of the organization, and the stage of development of that entity. On the other hand, an L-1A manager is a person who manages an organization, a department within an organization, or a function of the organization. They supervise and control the work of others. They have the authority to hire and fire workers, and they have discretion over the day-to-day activities and operations of the entity that they are managing. In general, USCIS loves to see that L-1A managers are managing professionals or that L-1A managers are managing and overseeing multiple levels of workers. So perhaps multiple levels of managers and professionals and workers underneath that. For both the L-1A executive and manager, the limit on the number of years that a person can hold L-1A classification is 7 overall. So they'll be granted L-1A status for 3 years or up to 3 years initially, and then they can extend in 2-year increments for a total of 7 years. As we said in the previous video, it is possible for a person to hold L-1A status and go through the green card process at the same time. That's because the L-1 classification is dual intent, meaning it's totally permissible to do both at the same time. In our next video, we'll be covering the L-1B classification in more detail. If you need help with an L visa or any other type of employment-based or family-based immigration process, please reach out to us. We would be happy to hear from you and assist you. You can contact us at info@sumnerimmigrationlaw.com. And until next time, I'm Emily Sumner.